Welcome to Devine Intervention, shedding light on Illinois property tax.
Hello and welcome to Devine Intervention, shedding light on Illinois property tax with Nora Devine. Nora has been a property tax attorney in private practice since 2005. She has developed a statewide practice in all jurisdictions in Illinois and represents all property classes. I am your host, Kevin Rosenquist, and in today's episode, we're going to discuss how to navigate the Illinois commercial property tax appeal process. Nora's going to give us the steps that you need to know. Nora, welcome back.
Thank you.
So what are some of the most common reasons property owners should consider filing a commercial property tax appeal?
Well, it depends. If you're in Cook County, you should just file it, because if you don't, you'll end up being the highest assessed property in the entire area. That's kind of the trend.
Because everyone else is doing it, basically.
It's unfortunate, but you have to appeal. If you don't appeal, you end up being the highest, and nobody wants that.
No. Are there specific signs someone should look for? Is it just seriously a blanket, just always do it?
Yeah, unless a property tax attorney tells you that you're underassessed, then you should be appealing like every chance you get. So it's unfortunate, but there's always this push-pull. There's always this struggle. Some of the assessing officials in the state of Illinois think that it's good for the residential taxpayers if you can increase the amount of money that the commercial tax base is paying. Mm-hmm. So every time the Board of Review wraps up its work, there's usually an article in the local press about whether or not the tax burden has shifted from residential to commercial or from commercial to residential. So there's always this historical push-pull between the two different property types.
What about outside of Cook County? You mentioned that in Cook County, is it different when you get out to Lake or DuPage or any of those?
Yeah, outside of Cook County, the further flung the jurisdiction is, the less commercial tax base they tend to have. The vast majority of the equalized assessed value in the state of Illinois is contained in the Chicagoland area. So that's in Cook County itself and in what they call the collar counties, which is Lake County, DuPage, maybe Kane, Will, maybe McHenry. So if you look at all the value of all the property and you add it all up in the whole state of Illinois, some overwhelming majority is in that northeast corner of the state of Illinois.
What kind of documentation or data should property owners make sure they collect so that they can have the strongest case possible?
If it's an income producing property, then the assessing officials are going to want to understand the income stream. They're going to want to understand what type of rents is this property able to obtain and what kind of expenses is it running. And they also want to know, how do those actual expenses and actual income, how does that compare to the market income? So in other words, like if you're getting $10 a foot for this retail building, but every other retail building in the entire municipality is getting $20 a foot, the assessing official may want some detail about why are you getting so much less on a per square foot basis than what the market is doing. And to the extent that you're getting less, or to the extent that you're getting more, the actual income should be disregarded and they should be using the market income. And you see that a lot in big box cases where you've got a high rental amount being paid because it was a build-to-suit. So the landlord built this property for this user in exchange for their promise to pay above market rent for an extended period of time. And so those rates can be above market. And so to the extent that a rental amount at a subject property is higher than the market rents, you're supposed to be disregarding it and using the market rents. And the converse is also true. We have a case in Illinois called Springfield Marine Bank, which was I believe it was a retail building, and it was owned by a trust, and the trust was held at Springfield Marine Bank. That's why they call it that. So the property wasn't a bank, but it was a commercial property, and it was held in trust. And so there was kind of a sweetheart deal on this property, and there was a below market lease. And the property owner very, 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 very much wanted their property tax liability to be based on this low below market rent. And they went all the way to the Illinois Supreme Court. And the Illinois Supreme Court said, no, to the extent that rent is below market rent, the assessor is correct to disregard it and to use market rents. And so that's the case that still controls. And that's the case that the Property Tax Appeal Board will apply if market rent in a commercial case is either above or below what the market rent is, as indicated by the other data points in the marketplace.
Okay. When it comes to comps, what should property owners look for as far as making sure that they have the right comps to support their claim?
It's always good to keep a sense of curiosity, obviously, about what is happening in the surrounding neighborhood. So
Sure.
if you have an income producing property, if it's a retail building, if it's an office building, you should naturally be curious about what the other spaces are renting for. What are the asking rents for all that vacant space that's anywhere near your property? You should want to know that for a lot of reasons, obviously, for your own leasing purposes, and then you should want to know it for your property tax bill, because an income producing asset is going to be analyzed based on how much income and how much expenses it has, and then how much risk there is in this type of property in this type of an area. And that's represented by the capitalization rate. So fundamentally, the sales prices are rooted in the property's ability to make money. And the assessing officials will care about the property's ability to make money, because it's just going to be an income approach to value if it's a multi-tenant leased asset.
What about if there's a lot of vacant space around somebody? How does that change their assessment and then the appeal?
Vacancy relief, we should probably do an episode just about vacancy relief, because it is a thing, and it's probably beyond the scope of this episode, but it's just basic principles of supply and demand. If there's a lot of vacant space, then the amount of rent you're going to be able to ask for your property that's also vacant is going to be lower. So that's just a basic economic principle. And, to the extent that you have a property that's only 50% occupied, there's going to be published resources out there that the assessor is going to have access to. And they're going to compare what's going on in the marketplace for that subregion to what's going on in your subject property. So if you're running 50% vacancy, but office vacancy for everybody else in that neighborhood is only 15%, then the assessing official may, rightfully so, ask you, what's going on with your vacancy rate? Why is it so much higher than the market? So you do have to be ready for those questions.
How can commercial property owners leverage income and expense data like rent rolls or operating expenses to help strengthen their appeal?
I think that the rent roll needs to be detailed enough to give the assessing official a clear picture of what kind of rent they're getting. Is it gross rent? Is it modified gross rent? Is it net rent? Is it somewhat net rent, but not really? So it's, how much of the common area maintenance is this tenant paying? How much of the real estate taxes is this tenant contributing? Is the number zero? Is the number higher than zero? And so, just putting the rent on there and not explaining what kind of lease it is really not a good way to express the income producing ability of the property to the assessor, because it creates more questions than it answers. So for us, we like to reconstruct the rent rolls that our clients give us if the rent roll is not detailed enough to show the breakdown between what is the rent, what is the common area maintenance, what is the real estate tax. So we actually reconstruct a lot of rent rolls just because we know that the assessing officials do want to see those components of the gross rent delineated.
And when someone comes into your office, when you start working with someone who's preparing for a commercial or is considering a commercial property tax appeal, what is your process? How do you start? What questions do you ask? What mistakes do they make that you help them kind of get over?
Sometimes it can be tricky when there's tenant improvement, allowances for let's say an office building. Maybe in order to get that new tenant, you have to agree to pay certain amounts in build out. So they're called tenant improvement incentives. And, I think that failing to account correctly for those on the rent roll can be a problem. And, failing to keep lease abstracts that accurately and comprehensively talk about exactly what mechanisms are at play, because it can look like you're getting great rent, but, you're kind of financing their build out too. And so, the appraisers like to deduct those tenant improvement incentives from the gross rent that they're getting. So if you just put in a gross rent number and you don't make any argument or any allowance for how much of that money is actually being put back into the property in order to create a build out suitable for that tenant's and perhaps only that tenant's use, then I think that that's where you run into problems. So you definitely want to make sure that the data is going in a complete and comprehensive way, and not in a kind of quick and dirty way that doesn't totally show that what the landlord is gaining here is a lot less than the gross amount that may be depicted on the rent roll. So as I say, sometimes you have to peel back the onion and find out exactly what's going on. What percentage of this lease amount is actually a financing transaction, whether it's a build-to-suit lease for a big box retailer or whether it's a big office tenant that's going into a new building. You need to be able to delineate between what's rent and what's the rest.
I know you said it, that everybody in Cook County should appeal, but are there ever situations where someone comes to you for commercial property appeal in Cook County where you're like, I don't think you should?
Yeah, sometimes if they came to me and they have a recent purchase and they paid a lot more for the property, I'll still take those cases because I know eventually that the sale won't mean much, and I'll be able to hopefully get the assessing officials to apply more of an income approach to value. But those are the most difficult clients because it seems almost impossible to manage their expectations up front. You try to tell them up front, you're going to be stuck with this purchase price for about 3 years before the assessing officials are going to consider anything else. And that's just the climate right now. That's how the assessing officials feel. It's like, well, you paid that. So, we're not going to put the value lower than what you paid. And this can be really difficult for a client who comes from a jurisdiction where it's legally impossible for a tax bill to double from 1 year to the next. But that's not Illinois. Illinois, it's completely possible for a tax bill to double or even triple from 1 year to the next. And then every time they get a tax bill, they want to call you and say, hey, aren't you even working on this? And you say, yes. And if you remember the 3 other conversations we've already had about this, you overpaid for an underassessed asset. And it is going to be a while before I am able to make a dent in your tax bill. And so those are the most difficult clients. And those are the ones that are wondering if I'm the problem or if I'm not doing enough, or, and you can tell them till you're blue in the face that it's the system and that they are going to stick you with this purchase price for about 3 years before they're going to consider anything else. But it's a really hard message for them to receive because, they bought this asset with the anticipation that their tax liability was going to be one thing. And then it turned out to be very different. It turned out to be double. It turned out to be sometimes triple. And that really frustrates the financial picture that they thought that they understood when they went into buying this asset.
And what factors do the Illinois Property Tax Appeal Board, the PTAB, and local tax assessors consider when they review the appeal?
I mean, the first thing they will look at is if it's sold. And if it's sold for an amount higher than the assessor's value, then that can carry quite a bit of weight. The only way to get around that is if you can show that the assessor took the value straight up to the purchase price and did not touch the assessments of similarly classified properties in the neighborhood code. That's what they call sale chasing, and it's illegal. It's not allowed in Illinois under the Constitution. So if you have a clear sale chasing case, and believe me, I've been doing this a very long time and I've only seen less than 5 that were truly, truly sale chasing cases where, the assessor took the value right to the purchase price and it resulted in the property being completely overassessed as compared to everybody else that was similarly assessed in that area. In those cases, you hope that the assessing officials will make a change to the value because you still do need to have uniformity of assessments. You cannot spot assess just because, these 5 sold over here, so we're going to reassess those and increase them dramatically. But then these guys over here that didn't sell, we're going to apply a mass appraisal system to those. That's not a legal situation.
What can property owners demonstrate to make their case stand out? Are there any specific things that you kind of like really know are good? Maybe not slam dunks, but at least close enough?
If you're appealing because you paid some amount for the property and the amount that you paid is less than the assessor's value, then you want to put in every bit of evidence that you can assemble that shows that your purchase was arm's length. What does arm's length mean? Arm's length means that it was between unrelated parties who were acting in their own best interests, who were adequately advised, and that the property had adequate exposure to the marketplace, and that neither party was under duress. That's loosely what the definition is from the International Association of Assessing Officers. And anytime that I'm promoting a sale as a market sale, I have this definition printed out and taped on my monitor, and I make sure that my work product hits on every single prong of this definition. Did the buyer and seller know each other? And you have to say they didn't, and you have to show they didn't. So if it's 2 LLCs, you can go to the state database and print out the record of who owns each LLC, and you can show there's no common ownership of these companies. And if it's that you want to show that it had adequate exposure to the marketplace, you can show the entire listing history. How long was it marketed for sale? Did a professional broker market it? What kind of marketing materials did they use? I love to put in really long broker affidavits for the most serious cases that I've had about sales prices that were way below the assessor's value. And I've put in 5-page broker affidavits in the past just because, what if the hearing comes and you can't get the broker? You know what I mean? Like, at least you've got this data in the record, and you've got the attachments, you've got the listing agreement, you've got all the deals that fell through and all the details from this broker about all the efforts that went into finding the market value for this property. And that's what brokers do. They're out there to get the maximum amount for the property that they can possibly get for the seller. This becomes very difficult because I represent a lot of banks, and I do a lot of OREO assets, that's other real estate owned. And when a bank is the entity that transferred title to the buyer, the assessing officials can have a presumption that this was not an arm's length sale, that this was distress sale. And so I am very good at fleshing out all the intricate details of like why this sale was arm's length, even though the transferor was a bank.
Okay. Wow. Yeah. A lot of moving parts to this whole appeals process, clearly. All right. Well, thank you for joining us on Devine Intervention, shedding light on Illinois property tax with Nora Devine. To connect with Nora, please visit thedevinelawgroup.com, and please like and subscribe to our channel. And Nora, thank you so much for being here. It's always great chatting with you.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.